Fiona Hines Lafon, KC, campus IP lawyer and featured speaker. Members of the panel, other members of the university community, specially invited guests, members of the media, and ladies and gentlemen. Welcome to the forum, Understanding Publication Rights and Publication Agreements, hosted by the University of the West Indies, Cave Hill campus. It is being held to recognize UNESCO World Book and Copyright Day, today, April 23rd, 2026. Good evening. My name is Dr. Yolande Cook. I am the Senior Program Officer in the Office of the Principal, and I am the co-chair this evening, along with my colleague, Ms. Beverly Wood, Librarian of Scholarly Communications in the Sidney Martin Library at the Cave Hill campus. This event is hosted by all of the libraries on the campus and the Office of Research, Innovation and Community, which we call RICH, at the Cave Hill campus. Every year, UNESCO designates a day to celebrate the power of books as a bridge between generations and across cultures. They recognize that books are like a window into another world. With each new page, books introduce new people, new cultures, and new ideas. Thank you for joining us as we celebrate publications in this forum entitled Publication Rights and Publication Agreements. Now it is my pleasure to introduce you to Ms. Pauline Nicholas, the campus librarian, to bring remarks. Ms. Nicholas?
Warm greetings to our esteemed panelists, our dedicated staff, faculty, student body, friends, visitors, wherever you are from, wherever you are, greetings from the Cave Hill campus libraries. Now, as we celebrate National Library Week 2026 under the theme, Find Your Joy, we pause to honor the library, not just as a repository of books, but as the beating heart of our academic community. The library is a space for conversation. It's a space for curiosity and discovery. This week has been a testament to our shared commitment to the pursuit of knowledge and the transformative power of information. In alignment with this year's theme and today's recognition of World Book and Copyright Day, the library is particularly pleased to partner with the Office of Research, Information and Community in this panel discussion. Very timely theme, understanding publication rights and agreements. In an era of digital repositories and globalized content sharing, the relevance of this topic cannot be overstated. Moving our discussion to this virtual space allows us to engage directly with the digital realities of modern authorship. This dialogue serves as a critical bridge between the creation of knowledge and its legal protection. So this afternoon, I look forward to the empowerment of the authors, librarians, editors, students, all of us, as we seek to navigate this publishing ecosystem. I therefore acknowledge that our presenters are drawn from different islands out of Barbados, and therefore understand that this discussion will help us to ensure regional sovereignty as Caribbean scholars maintain control over their data and narratives within the print and the digital publishing space. Though we are meeting on screens rather than in the stacks, I'm looking forward to a robust discussion because our goal remains the same, and that is to ensure the Caribbean voice is not only heard, but protected and preserved for generations to come. Therefore, I look forward to the participants' presentations and the discussion that will follow, and what promises to be a transformative session, not just for me, but all of us who are online. Therefore, thank you, everyone, and have a good evening. I look forward to what will be presented. Thank you.
Thank you very much for your warm remarks, Ms. Nicholas, campus librarian. For those of you who have joined us after we started, this is a forum on publication rights and publication agreements hosted by the libraries and Rich of the UWI Cave Hill campus. As Ms. Nicholas said, we have a program of interesting topics and experienced speakers. Next, we will hear our featured speaker, and that will be followed by a panel discussion and a question and answer discussion session. We ask that you put your questions in the chat, and we will gather them all for the question and answer session after the panel discussion. The featured speaker this evening is Ms. Fiona Hines-Lafond. She will speak on the topic, ownership of copyright. Well known and loved to the campus and the legal communities, Ms. Hines-Lafond is an attorney at law currently practicing as a private practitioner at the law firm Carrington and Seeley in Barbados. She heads the Intellectual Property Department and co-heads the Credit and Securities Department. Ms. Hines-Lafond holds a postgraduate diploma in UK, EC, and US copyright law from King's College London. She has attained many certifications, including certifications in licensing of intellectual property law and international trade and intellectual property law. Throughout her legal career spanning more than 3 decades, Ms. Hines-Lafond's qualifications allow her to provide legal advice in a multiplicity of legal areas, including intellectual property law, dealing with issues of trademarks, copyright, patents, geographical indications, unregistered marks, rights arising from databases, and data protection legislation. She has presided over the Advisory Committee on Intellectual Property Law for the Barbados government and more recently assisted the review of the draft Copyright Bill of Barbados. Additionally, she is part-time lecturer and course director at the Cave Hill campus, specializing in intellectual property law. Ladies and gentlemen, join me in welcoming Ms. Fiona Hines-Lafond by using your clapping hands emoji as she comes to give her featured address on ownership of copyright. Ms. Hines.
I'm going to start by saying Fiona, because it feels weird to hear that long treatise, it sounds like. Anyway, so I've been asked to speak to you on ownership of copyright. I debated, I've been given a time frame, and so I will try to meet all demands. I tend not to be a lecturer reading notes, but I will, for this purpose, read some. And at some point, I will digress, okay? But the notes are available should the campus request them. So, ownership of copyright. It is impossible to understand publication rights and agreements without fully appreciating the rights of the owner. And you'll notice I said the owner and not the author, but I'll get back to the author, I promise. Copyright legislations globally share a commonality. And that commonality is that only the owner has the right to exploit the work, and equally, only the owner, or indeed the exclusive licensee or authorized licensee of that owner, has the right to sue for infringement, subject to legislative restrictions. So my job today, as I pondered on how to present to persons who are creatives, because that's what each of you in your own right will be, is not to burden you with the academics of the subject matter. I can invite you, however, to do the university's courses on intellectual property. I will resist from using too much of an academic treatise or an academic approach, but I will apologize in advance for the lawyer in me, combined with the previous part-time judicial judge in me, combined with the academic in me, has no choice but from time to time to revert to references to case law or legislation. To give context, all intellectual property rights are statute-based rights. They exist as a result of statute. They don't just come out of the air and land, okay? The land complements a parliament somewhere. So it's impossible to understand the copyright of your jurisdiction without pulling the relevant copyright legislation. They are statute-based. As such, the role of the owner is statute-based. So where do we go from there? Copyright is a right which subsists automatically in a work, provided that your legislative framework, and you're from different parts of the globe, but your legislative framework deals with that work. Why do I say that? If I look at the UK and Barbados, for example, they have a closed box of works, literary works, artistic works, dramatic works. It's very closed. Whereas the EU, way broader. They try really hard not to close their creative juices. So their legislation tries really hard not to box in the works that will be protected in copyright statutes. And to this end, I just want to reference that the Trinidad and Tobago Copyright Act is an interesting piece of legislation because it tries really hard to blend, if you wish, the EU approach within the context of the traditional British UK approach of closed works. And I'll return to that. So as I said, copyright is a property right which subsists automatically. It subsists as a result of the creator, the author, we will call him or her. And the author is the person that uses his or her own skill, labor, and judgment, or using the EU approach, his or her own intellectual creativity or own intellectual creativity to create the work. The author is the first owner unless there's a contract to the contrary. The author can be joint authors, okay? So when you think of a literary treatise in academia, more often than not, you see joint works being created. And the author is the first owner unless there's a contract to the contrary. I pause briefly to say that as we watch the world of AI unfolding, it is impossible not to touch artificial intelligence. Artificial intelligence creates also. There is simply no doubt about that in this year, 2026, Anno Domini. Artificial intelligence, however, has not been given to the second the rights of authorship and ownership pursuant to copyright legislation. And I am not a believer in giving it at all because you can't lock up a robot. Where are you locking the artificial intelligence up if it infringes? Where? There's no jail that can hold it. But the point is, more importantly, that one has to really appreciate that copyright is protecting works created by a human body or a corporate personality, a company structure. And in each of our legislations, it doesn't now matter where you're from, the term author is defined, and often the term qualified person is equally defined to reference a human individual. It doesn't use the word human, but an individual being a person who is citizen of country X, or a body corporate. A body corporate is a company which is registered under the laws of country X. So just to say that our definition of author as at this second excludes non-human or non-corporate creations. That's good, helpful for everybody in this room who's a human creator. Not so helpful if you're using AI to create, okay? There is a wiggle room in the prompts that can be used by the human into the AI to create the work, but the legislation hasn't yet addressed it fully, okay? So there is argument that the prompts might result in a copyright work, but to this moment, the legislation has not addressed it, and it's been left to a large degree to case law. For my purposes, I'll just very briefly say there are very few AI cases, but there's the case of Thaler, and it's a US case first, which made its way into the UK jurisdiction, in which the court emphatically upheld that only a natural person can be named as the inventor on a patent in application. It wasn't a copyright case, but I suspect the same approach will be held if challenged, okay? And so we keep that in mind. So let us return. We leave AI one side and we return to the humans in the room. So the author is the creator, and that is the person who uses his or her own skill, labor, and judgment, or own intellectual creativity to create the work. It's a de minimis standard, which means you just have to use your own. Just don't copy it, okay? Yours, no one else's. And to every creative in this room, there is, in our region, no mandatory requirement to register the work in a corporate registry or an intellectual property registry, okay? In fact, you don't even have to see a lawyer. In fact, you have to do very little to make the work yours, and that's really important. So there's no little piece of paper that you have to get to create the work. That's great, by the way, until you get to publishing agreements, which I'm going to get to very soon. So this creator, as the first owner, has the right to exploit the work. And if you, again, go to the simplest form of exploitation, it will be copying. And if you go to the simplest form of understanding copyright, it will be copyright. That's the name of the act. Right to copy. Don't make it difficult. Real simple. Copyright. Right to copy. So the question is always, when dealing with publishing agreements, who has the right to copy and who has the right to give instructions allowing for that copying, okay? And so you have to bear that in mind when it comes to publications and publishing agreements. I said to you that the author is the first owner unless there is a contract to the contrary. Very quickly, I will say that the Barbados legislation, for example, identifies certain types of contracts, the employment contract, the commissioning contract being two of those. And if a work is created, therefore, in the course of employment contract, the employer is the first owner. And if the work is created as a result of a commissioning contract, the entity commissioning it is the first owner. The author meaning the creator in the first place. This course is not going to go into how does one know if the employer is an employer, if the employee is an employee. I just want to say that I am forever grateful for the erudite decision of Sir David Simmons, the former Chief Justice of Barbados, in the case of Carter against Sagicor, who actually uses a copyright case in his judgment and who goes into examine the multifactorial approach that one takes in ensuring that you understand if there's an employment contract arising from the relationship. Similarly, there are a few cases in Jamaica, which I do reference for commissioned works. Grace Kennedy comes to mind. And again, you're looking at the facts. If there's no written contract, you'll have to look at the facts behind why the work was created in inferring if there's an implied contract. Just for an aside, before I get back to publications, Contracts don't have to be in writing. The lawyer in me says, put them in writing, make it simple. The realist in me says, you might not. And therefore, you can remember that contracts can be oral contracts. And you just have to now look at the terms and make sure that the contractual requirements are met for purposes of that arrangement. So returning then to the rights of the owner, because this is about the owner. If the owner remains the author, then the author as owner will have the right to exploit the work. And the legislation actually tells you, Barbados Section 9, the ways that you can exploit the work. And in essence, as I said, copying the work, issuing copies of the work to the public, performing the work in public, broadcasting the work, to name a few. Equally, the owner is the only person who has the right to sue for infringement. And this has been tested neatly in St. Lucia, in a Megaplex case, and in Barbados, in the case of Copyright Society of Composers, Authors, and Publishers against Cable and Wireless. And Justice Cornelius reinforced in her judgment, and I quote, that a claimant has to establish that on a balance of probabilities, it is the rightful owner of the copyright or an exclusive licensee of the owner in order to sue. So if you can't establish you're the owner, you can't sue, okay? Full stop. And so in that case, the case was struck out. And even though the work was being used, nothing, okay? Because the wrong person sued. So returning then to the overall title, when one thinks of ownership and now brings it home to publication, one has to ask, where does the owner fit in a publication contract? I thought for this purposes that the easiest approach given my audience is to perhaps create a best practice list. And I say that because the publication agreement can be with the author as owner. That's where the author has not done it in the course of employment. Or it can be with the owner alone, the author having sold the work or the title to the work by a previous arrangement. So the best practice always in a publication agreement is for the contract to clearly state who created the work. Start with step one, okay? And I say that against the backdrop that the duration of time in which the work is protected under the laws of copyright are set in the statute wherever the citizen was. So if it's in Barbados, 50 years after the year of the death of the person, okay? Full stop. Jamaica is a little bit nicer to us as creators. If you're there, I'm not there, but it'll be 95 years. And the Eastern Caribbean, because I see Mr. Shong, I'm assuming St. Vincent. So the time frame varies in the Eastern Caribbean between 70 and 75 years between St. Vincent and Dominica and the other Eastern Caribbean islands. So what one sees is that in the Caribbean region, we have a wide range of duration times. And I think that that's something that ought to be addressed, given at bare minimum, the fact that the University of West Indies spans all of these countries. And we teach persons in all of these countries, but more importantly, our creators might be doing joint works with persons in varying university countries or otherwise, okay? So it's something that I think is a go forward in our legislative parliament. So, apologies. So then the publication contract sets out who the author is, and that's important. The publication contract needs to also establish who the owner is. So if the author has parted with the title, okay, if it was land, it would be real simple, you know. I say to you, do you own this land? Yes. Here's my deed. Yes. Or I get this a lot. Yes, I own the land. Okay, where's the deed? Granny hasn't given it to me yet. Granny hasn't given it to you yet. No, and Granny has given it to Mummy and Auntie and Uncle. I'm actually only the grandchild. And then you pause. Sweetheart, you don't own the work. Stop. You don't own the land. If I had to teach this, I would say to you, you put on goggles for copyright, and you take off the goggles when you can't see, and when you understand, you put on the goggles and you understand that all property is the same. Don't make it difficult. All property is the same. So with copyright, who is the owner? Different to land now, there's no registry. So you're requiring the person to be honest, to be clear, and you're requiring them to make warranties that if they're not the owner, you can sue them for some form of redress, okay? So that's the second part of that contract. Now, publication contracts, remember I said to you that the rights on the exploitative rights are set out in the legislation. Copyright is special. You can have a contract, a publishing agreement for your current works. You can also have a publishing agreement for your future works. You can have a publishing agreement for your current works limited to one geography, or you can have a publishing agreement for your worldwide works, including future worldwide works. You can have a publishing agreement for print. You can have a publishing agreement for digital. You are the owner. Take off the author hat. You're the owner. You determine the scope of that publication agreement. I accept, however, that the publisher is a huge body within that negotiation. So depending where you fall, everybody has different negotiation strengths and capacities, okay? But the reality is, once you sign it, you've agreed it. So the term of the use of the work is really important. The extent of the use, the type of use, the type of, the duration of the use. Now, there's something else. What did I say to you in the beginning? And I'm going to wrap up. I'm very cognizant of time. But what did I say? I said the author is the first owner unless there's a contract to the contrary. Just keep that in your brain. I said to you that contracts to the contrary can be employment contracts, for example. And what I love about the Jamaica legislation is they just say that, by the way. They don't give examples. So you don't get sidetracked, okay? But anyway, it could be employment contracts. It could be written contracts, which are assignments. It could be implied contracts. The contract could be inferred due to the circumstances. Why was the work created? Unjust enrichment says you can't benefit twice. So keep that there. But regardless, the owner, when they're exploiting the work, has to be cognizant that contract is their best friend. So the publisher is going to have those ready-made contracts, okay? That's the reality, okay? They do them all the time. It doesn't mean you can't go through and say, am I agreeing this? The law of contract says once you've signed it, you've agreed it. I move from there to say that you have to make sure that consideration is fair. That's royalties. How they're paid. Are they paid in advance? Are they paid in arrears? You're the owner. You have the right to exploit the work. The essence of a publication agreement from the perspective of the owner, I've forgotten the author now, by the way, is that contractual terms must be clear. It is impossible for the owner to deal with the work. It's impossible for the owner to deal with the work and be vague. Contract lawyers don't like it. Judges don't like it. The rule of contract says you must be clear. So the rules of contract, remember, what are you contracting? If you're not the author, how did you get the title? Did you buy it? Did you buy it from 4 different people? If so, prove it. Because only the owner can contract, and the owner might not be the author, might no longer be the author, because there might be a contract to the contrary. To revert then to some due diligence, my sincere apology. To revert to some due diligence, the essence would be, what is the author granting? Is it an assignment or is it a license? Pause. A publishing agreement is very interesting. If you assign the work, that's code in copyright law for selling it, transferring it. It is no longer yours. If you license the work, that's code in copyright law for renting it. I'm using that language because we know what land is. So we know what to own land is versus to rent land. Same concept, okay? So if you go and sign a contract with a publisher to assign the work, pause. You no longer own it. If you sign a contract to license the work, pause. It will revert to you at the termination of the contract. You have to look to make sure that warranties and indemnities are in that contract. The work must be original. It has to be yours. Nobody wants to publish a work and then get sued. I will guarantee you. So the owner, if they're not the author, has a duty to make sure that they know as best as they can that the author was the only person, or if it's joint authors, that the joint authors are the only persons that created the work, sorry. And lastly, the editorial process. You may want to consider, do you want to have an active involvement in the editing or the publication or not? And with poetry, I just digress from law. With poetry, formats are sometimes very important. So you will see that people do stanzas in different ways. They publish in different ways to bring across a message. And of course, if it's a license, the reversion clause. I close by saying the author is the first owner unless there's an agreement to the contrary. I close by saying your job is, am I the author? Did I create it alone? Or did I forget the best friend down the road who worked with me at the coffee shop? Because they will sue you for infringement. So you have to know who is the author. If it's joint authors, be upfront and deal with that. Then you have to understand, what do I want to do with this work? If I am the owner, I'm going to choose and negotiate the publishing agreement and how I want it to go theoretically, subject to where you fall in that ladder in the publication agreement, because of course you have different strengths in the room and different players, but don't sign it if you don't understand it. And legal assistance is always recommended. So thank you to everyone in the room. Happy World Copyright Day. Happy Intellectual Property Day also. It's on Saturday. And all the best for your meeting ahead. Timing.
Thank you so much, Mrs. Fiona Hines-Lafon. We are off to a very good start, everyone. And coming up next, we will have the panel discussion, but be sure to put your questions in the chat. We are monitoring the chat as the program progresses. So at this point in time, we are going to start our panel discussion, and I'm going to introduce you to our moderator. Our moderator this evening is Dr. Adetutu Polemo. Dr. Polemo is a legal scholar and lecturer in the Faculty of Law here at the Cave Hill campus of the UWI. She also serves as Deputy Dean for Graduate Studies and Research. Dr. Polemo holds a PhD in labor law and industrial law and specializes in sexual harassment law, gender studies, labor law, intellectual property law, and constitutional law. She has over 50 peer-reviewed publications and a strong record of academic leadership in Nigeria and elsewhere. She's widely recognized for her contributions to gender justice and workplace rights. Dr. Polemo is also a practicing barrister, a notary public, and an associate member of the Chartered Institute of Arbitrators in the UK. We're going to allow Dr. Polemo now to introduce her panel to you. Dr. Polemo?
Thank you very much. And I'll stand on existing protocol. So thank you very much for the warm introduction, and it's a pleasure to be a part of this program. So without wasting much of our time, I stand on existing protocol. Good evening, everyone, and I welcome you all to today's panels on understanding publication rights and publication agreements. This is a very important conversation, particularly for researchers, academics, emerging scholars, navigating the publishing landscape, especially on special day like this, which is the World Book and Copyright Day. We are privileged to have with us distinguished panelists of experts who will bring both scholarly and practical insights to this topic. So I'll begin by introducing our first panelist, starting with Miss Christine Randall. Miss Christine Randall. So I'll take a brief biography. Miss Christine Hay Randall is a strategic, solution-oriented, and result-driving publisher with over 15 years of market-leading commercial management and over 20 years of broad-based experience in all areas of publishing operations. A qualified attorney at law, she earned a Bachelor of Laws in 1993, London School of Economics and Political Science. She was then admitted to the Bar of England and Wales at Gray's Inn in 1994 and the Bar of Jamaica in 1995. She was previously the managing director of Land Randall Publishers from 2007 to 2022, where she oversaw the development and expansion of the title list and the company's global reach. Christine is now the director of the University of the West Indies Press, having taken up the appointment in January 2023. We are delighted to have you as one of our panelists in this webinar. So I would like to introduce the second panelist, Professor Emeritus Alan Cobley. I will take his brief bow shortly. Professor Alan Cobley is an emeritus professor of history at the University of West Indies KV campus. His many publications include 3 single-authored, 3 edited, and 7 co-authored books. Cobley has been a member of the editorial board of the Journal of Caribbean History since 2001 and has served as editor of the Journal of the Barbados Museum and Historical Society since 2025. He was Vice Chancellor for Undergraduate Studies at the University of West Indies from 2013 to 2019. His membership on regional bodies includes the CARICOM Human Resource Development Commission, 2016 to 2018, the Caribbean Examinations Council, 2013 to 2019, and the Rhodes Commonwealth Caribbean Scholarship Committee, 2025. He currently serves as chair of the advisory board for the West Indies Federal Archives Center. So we are delighted to have you with us, Prof. I would like to introduce our next panelist, Mr. Bruce Lochner. Mr. Bruce Lochner was born in the UK in 1945, but has been resident in the Caribbean since 1973 and is now a citizen of Trinidad and Tobago. He joined CADI, Caribbean Agricultural Research and Development Institute, in 1979 as the biometrician. He moved into senior management in 2000 and spent the next 10 years in various positions, including manager of research and development, chairman of the Publications and Seminar Committee, and 3 spelled as acting executive. That's 3 years spelled as acting executive director. He considers it very important that senior managers remain professionally focused and remain as CADI's biometrician up to retirement in 2010. Since retirement, he has been very active with many consultancies, and since 2020 has been editor-in-chief of Tropical Agriculture, the Journal of the Faculty of Food and Agriculture, University of West Indies St. Augustine campus. The journal is over 100 years old and currently publishes articles from Nigeria, Ghana, Burkina Faso, Algeria, Iraq, India, Ethiopia, Philippines, Indonesia, and many other countries, including the Caribbean and Latin America. Mr. Lochner's publication list has over 100 entries as senior and junior author in reviewed and other publications. We are delighted to have you as one of our panelists, Mr. Bruce Lochner. I would like to introduce our next panelist, the person of Dr. Halima Dikshon. Dr. Halima Dikshon is currently senior lecturer and university director of the Institute for Gender and Development Studies, IGDS. She is former head of the IGDS NITA Baron unit at the Cave E campus. An experienced feminist researcher, she's published in the areas of sexual and gender violence, feminist methodologies, anti-colonial feminisms, and qualitative interviewing and analysis. She is the co-editor of Methodologies in Caribbean Research on Gender and Sexuality and Interdisciplinary Perspective on COVID-19 in the Caribbean, Volume 1 and 2. Dr. Deschamps was also the lead researcher and author of the qualitative components of the United Nations Women, CARICOM, Caribbean Development Bank Women Health Survey on Violence Against Women in Grenada, designed the National Gender-Based Violence Action Plan for St. Vincent and the Grenadines, and jointly designed 2 gender-based violence, health and family life education curricula for secondary and post-secondary school students in SBG. She has also created operational guidelines for mainstreaming gender in disaster resilience actions in Grenada. A former Vincentian ambassador to the United Nations, Halima is recipient of the 2024-2025 Principals Award for Excellence in Research and Public Service at the University of West Indies, Cave E campus. We are delighted to have you in our midst. The last panelist on my list, but not the least, she is Miss Mylan Douglas. Miss Mylan Douglas is the head of the Law Branch Library and coordinator of the Technology Innovation Sports Center, Intellectual Property, CISC IP EPDEX at the University of West Indies Mona campus. Ms. Douglas, a fully qualified law librarian, read for a Bachelor's of Law LLB at the KV campus and pursued the Legal Education Certificate, LEC, at the Norman Mali Law School. She also gained Legal Research Certificate from the University of Toronto. She delivers annual guest lectures to Mona Law students in foundation and research law courses. Ms. Douglas specializes in complex and advanced legal research, providing confidential legal scenarios, research in academic library settings, building law library collections, and networking to raise awareness about data protection and research innovation and services strategy. She is currently the WIGOT Mona Vivian's Secretary, the 2026 Secretary of the Library and Information Association of Jamaica, and a former president of the Caribbean Association of Law Libraries within the year of 2022 to 2024. So, having read that, we are delighted to have all of you as well as our panelists for today's discussion. So thank you all for joining us this evening once again. We are truly looking forward to an engaging and insightful discussion with our panelists. So we just welcome our panelists to begin to give us their talk on the subject matter. To begin, I would like to invite Ms. Christine Randall to share opening thoughts on publisher rights, publication royalties, perspective of a publisher, Dewey Press, in 10 minutes. You have the floor, Ms. Christine Randall.
Thank you very much, Dr. Pelemo. Colleagues, good afternoon, good evening, welcome, welcome. Thank you for the opportunity to share. It's fortuitous, actually, that I'm following on from Fiona and her keynote on copyright and authorship and ownership. As a publisher operating in the Caribbean scholarly ecosystem, particularly at the University of the West Indies Press, we occupy a unique space, one that bridges global academic standards with regional intellectual priorities. As Dr. Pelemo just told you, I'm exploring the 2 interconnected pillars of publishing, the publisher rights and publication royalties, which, follows naturally on from Fiona's presentation. And how these things actually operate within our Caribbean realities. I hope that I am able to share my screen. So I will speak while the presentation. I hope you're all able to see the screen. Yes? Okay.
Yes, please.
Okay, lovely. So, what do we mean by publisher rights? At its core, publisher rights stem from copyright, governed internationally by frameworks like the Berne Convention for the Protection of Literary and Artistic Works, and of course, locally by national copyright laws. Again, Fiona went through all of that with you. When an author signs a publishing agreement, and something I wanted to underscore, your ownership, your copyright exists from the moment of creation. From you have created that work, it belongs to you. But I digress. So what do we mean? At its core, publishing rights stems from copyright. And that is when an author signs a publishing agreement, they typically grant to the publisher certain rights. And those rights are the right to reproduce and distribute the work, the right to license the work in different formats, print, digital, audio, and the right to sell subsidiary rights, such as translations or adaptations. As Fiona said, our contracts are drafted by the legal unit of the university, and we have certain templates. And at the beginning, once we're in a position or have decided to offer an author a contract, I typically send them the standard template and I ask them to review, look at it. Is there anything you wish to raise, anything you wish to ask? I have to say that unfortunately, invariably, people are so happy to get a contract that they don't look at it. They don't read it. They just sign. And I have seen in the past where some rapacious publishers have taken advantage of authors. So I guess my very first message would be, don't be afraid to review your contract and to ask questions and to ask what certain things mean. Those things are important. And you have to be cognizant of what it is that you are giving away. What it is, are you licensing or are you assigning? So those are some of the key things that we need to be aware of. But why do publisher rights matter? Why is the publisher important? From a Caribbean standpoint, these rights are not merely legal tools. In small developing markets like the Caribbean, they're essential for ensuring that regional scholarship reaches global audiences, thereby securing global visibility for Caribbean scholarship. And it's essentially, especially if you work with UA Press, rather than asking for a seat at the table by trying to get your work published by one of the big conglomerate groups. The UA Press has built the table for you. You don't need to go any further. And in conjunction with that, it is a protection of intellectual sovereignty, especially in our post-colonial contexts. That adage, until the lion learns how to write, every story will glorify the hunter. And so what we do as publishers is ensure that we in the Caribbean are telling our own stories. And then, of course, the publisher is the one who has the reach. The publisher is the one who is the professional. In this day and age, everything is accessible to everybody. But as we all learn, in the end, you really do still need the publisher or the professional who has the actual skill and expertise. And so the way it works generally is the publisher makes the investment, and why we need the rights that you grant to us in the contract is we need to be able to recover costs in our relatively small markets. But of course, we need to strike a balance. Authors are not simply content providers. They are our intellectual partners. So what are royalties? Royalties represent the financial return to authors for the use of their work. In most academic and publishing context, royalties are calculated as a percentage of net receipts. Just to break it down, whatever we get in our hand as a publisher, the author gets a percentage of that based on what you have negotiated in your contract. And net receipt, I'll just give you a little background. If your book has a retail price of $35, the press is not getting $35. The nature of the industry is that we have to give discounts depending on the volume, depending on the type of purchaser, whether it's a retail purchaser, a wholesale purchaser, or an individual purchaser. So we never get the full retail value. What we get is a net value, and we share that net value with the author. Those in the academic context, I have seen author royalties as low as 0. There are some authors who decline to accept royalties, but the typical royalty for an academic work is 5 to 10%. And sometimes, depending on the work, depending on the author, depending on the possibilities, it could be a percentage of that retail price. Fiona alluded to how royalties are paid. I will tell you that in our dispensation, in the academic forum, we don't pay advances. Our reality, our economic reality is such that we don't have money to take out and pay to an author in advance of royalties. Our royalties are always paid in arrears, again, which is a reflection generally of our Caribbean reality, but also that is typical in the academic sphere. It is really in the literary fiction market, big blockbuster sellers where you find advances being offered. And so what are our realities? We have a small market size, so our print runs are quite limited. And this is of the print book. They can be as low as 300 to 500 copies. Gone are the days when we used to print 2,000 and 3,000 copies. Of course, this constrains revenue and by extension, the royalty earnings. We are stymied by high production costs. Shipping, printing, distribution are relatively high in the region, which of course affects pricing and margins. And then, of course, there is our educational mandate, the mission-driven nature of scholarly publishing. Publishers like the UWI Press often prioritize knowledge dissemination over profit maximization. So this can mean lower royalty rates, but that is offset by our higher commitment to visibility, longevity, and scholarly impact. All of this, of course, has been affected by digital transformation, which in essence is an expansion of formats. We are no longer just publishing text, we are publishing knowledge in multiple formats: ebooks, multimedia scholarship, audio, AI-assisted workflows, and a general shift from print to digital first publishing. The impact of digital publishing on the publishing sector has been profound, leading to increased accessibility, reduced costs, faster publication cycles, and new creative possibilities. It has, however, also posed challenges related to copyright, piracy, and changing reader habits, requiring publishers to adapt and innovate to remain relevant in the evolving landscape. The shift to digital formats has implications for cost and royalty structures, naturally. Traditional books are priced high and you see naturally less sales. Digital formats are priced lower and we are able to expand the volume and make works more accessible. So ebooks and to a lesser extent, open access models are changing the landscape. Digital formats reduce printing costs, but introduce questions of how royalties should be calculated. Again, a question of negotiation, and you might find in a publishing agreement there are different royalty rates for the different formats. Again, something Fiona alluded to in her presentation.
The UWI Press digital editions improve student access regionally. And I will just point out here, for example, the use of the work of UWI Press works on the Caribbean Civilization course across the UWI network. And that is, accessed generally. We have found an uptick in access through our app and for the digital works as opposed to the print works. And of course, in the last month, we saw an exponential increase in our audiobooks. So that is a new avenue that we are going into in terms of exploiting our works as much as possible. But there are some key tensions. Access versus compensation. There's a strong ethical imperative to make Caribbean scholarship accessible, especially to students and institutions with limited resources. But authors deserve fair compensation. There is also this tension of global and local rights. Caribbean publishers must often negotiate retaining Caribbean rights while perhaps licensing international rights to larger publishers if we feel we can't reach a market or another publisher would be better served, which would ensure wider distribution without losing our regional control. And then, of course, we have to contend with piracy and copyright infringement, informal sharing, unauthorized copying, both physical and digital. They remain a challenge. While often driven by affordability issues, which we all understand, it directly impacts royalties and sustainability. But what are some of the best practices for fair and sustainable publishing? From our perspective, a balanced publishing ecosystem requires transparent contracts. As I said, feel free to ask questions, ask for explanations. Authors should clearly understand the rights that they are granting and the royalty calculations and rates. You should understand that there are, flexible models, including non-exclusive or territory-specific agreements. There are hybrid publishing approaches where, you might combine print with other formats, or you might combine other formats with open access options. And then, of course, capacity building. As I said, at the press, we remain open to working and educating our authors about intellectual property and publishing economics. It really is a relationship of trust between author and publisher. And so I've put there the role of UWI Press, which we have discussed already. We are the gatekeepers of quality. We amplify the regional voice. And we are a trusted brand in this AI era with our rigorous peer review process and the integrity of our editorial and production process as well. So in a world that's flooded with information, credibility has become a competitive advantage. And so looking ahead, Caribbean publishers must continue to innovate, embracing open access funding models, including institutional and grant support, perhaps leveraging diaspora markets to expand reach and revenue, strengthening collaborations among universities and other publishers, and of course, advocating for stronger copyright enforcement frameworks. In doing so, we ensure that Caribbean voices are not only heard, but sustainably supported. In the end, it is a balance between access, compensation, and regional knowledge production. Thank you.
Thank you so much for the insightful, detailed, enlightening talk. We have really learned from what you have given to us this evening. And then I will encourage that our audience post their question into the chat box. And then while we are waiting for the discussion and question and answer section so that we can post our question to the panelists, I'd like to invite the next panelist, which is the person of Professor Emeritus Alan Cobley, to give a 10-minute talk on pre-publication permissions and restrictions, use of third-party materials, perspective of book and journal editor. So, Professor Emeritus Alan Cobley, you'll have the floor, please.
Thank you, Dr. Palermo. Thank you for your introduction. Thank you also to Yolanda and to Beverly Wood, who invited me to be part of this panel. Now, when Beverly invited me, my first instinct as a historian was to wonder why there is a World Book Day. And so I checked. And apparently, it originates with the Cervantes Institute in Spain, Barcelona, Spain, who began a celebration in 1923 of Miguel de Cervantes, the author of Don Quixote, who was buried on the 23rd of April, 1616. Now, the 23rd of April also happens to be St. George's Day. So traditionally, the day was marked by the giving of a present of a book and a rose. Now, in 1993, Spain adopted, through a royal decree, adopted Book Day for the whole of Spain. So it became a national celebration. Now, UNESCO then took it up in 1996 and adopted the 23rd of April, of course, because Spain already had that day as a book day, but also because it happened to be the anniversary of the death of William Shakespeare, who also died on the 23rd of April, 1616, by strange circumstance. So UNESCO adopted the day, and on the first day that they adopted, they celebrated in April of 1996. They said that the purpose of the day was, quote, to raise global consciousness about the important role books play and have played in societies the world over. And it's interesting, of course, that from the beginning, although it was a celebration of books and reading and the cultures embedded in that process, copyright was also a fundamental aspect of the celebration and the annual commemoration of books. Now, much as I would like to give you all a book and a rose this evening, I'm not able to do that, even virtually. I apologize. And it is true that I would like to follow up the theme for today, which is Find Your Joy, by talking about the joy of reading and of books and so on. But regrettably, I've been given a much more prosaic and technical topic to deal with, and that is, as you've heard, the topic of pre-publication permissions and restrictions, the use of third-party materials, from my perspective as a book and journal editor. So what I'm going to do, I'm going to talk a little bit about the author's responsibility, the editor's responsibility. I want to go on to talk about the relationship between the process of editing and copyright. Briefly to talk about digitization, as Christine has touched on. And I want to end by talking about editing in the age of generative artificial intelligence. So that's the kind of agenda that I want to follow. So, pre-publication permissions are an important step in the process of producing any written work, whether a book chapter, or an article. And they are designed to ensure that the intellectual property rights of others are not infringed in the preparation of a new work. Now, such permissions may relate to the use of extended quotations of text, images, graphs, tables, or the use of other illustrations, which are the original creation of others. So pre-publication permissions and restrictions are also used to ensure that a new work is legally compliant in other ways. So, for example, to ensure that rules of confidentiality are not breached by quoting an oral history interview, for example, without the permission of the person who created that interview, or ensuring that nothing is published that is potentially libelous to a third party, that nothing is published that is legally obscene, and so on. Pre-publication permissions and restrictions cover a range of different things. of which copyright is part. Now, when it comes to a contribution to a contributed work, a collected work, whether it's a book chapter or a journal article, both the author and the editor have important responsibilities. That responsibility, of course, is to ensure the proper use of any third-party materials in that work. I want to start with the responsibility of the author. Generally speaking, it's the responsibility of the author to ensure that the necessary permissions for the use of any third-party material are in place. They usually include evidence in the form of written permissions from the owner of the copyright for use of extensive quotations or images, etc. And one of the things to remember about this, if you're an author, is that permissions can take a long time to get. It's a process that can take months. And so editors always advise authors to start early in obtaining the requisite permissions, ideally before submitting their work for publication. Secondly, authors should ensure that they have documented everything about the written permissions they have obtained from copyright holders. This is to ensure that any special conditions or restrictions required by the copyright holders are noted and complied with in the new publication, and also to ensure that you have something for reference if there are any subsequent disputes about copyright, about use of copyright. Now, one important point to note for authors, I think Halima will talk about this in a minute, is that it's important to read the contract before you sign it, whether it's with the publisher of a book, an article, or a book chapter, especially the clauses covering the author's responsibilities, which includes, as I said, getting those copyright permissions, and the right the author retains to the use of their work, or the rights they retain in their work after publication. As I say, Halima is going to address this more directly. Now, in our journal of the Barbados Museum and Historical Society, we have a set of guidelines for submission that go to authors. I'm not going to quote all of them, but there is one interesting clause in that, which I'm going to read. And this is in, as I say, in our guidelines for authors. Quote, "The article manuscript must not contain anything that may be subject to litigation on the basis of any content that may be considered abusive, defamatory, libelous, and obscene, or in any other way may be considered fraudulent, illegal, or offensive to the cultural norms of any society where the journal may be sold or distributed." Now, I read that out because I've never read a clause like that in any other journal, but I find it's actually quite a useful statement. One thing that the journal's submission guidelines do not include currently is a statement about the use of third-party materials, the issue of copyright of third-party materials. And so currently we're revising those submission guidelines to include a statement on that matter. Now, turning to the responsibilities of the editor, and of course, part of my responsibility is to make sure that the guidelines for authors are appropriate. It is the responsibility of the editor to ensure that the necessary permissions have been given and that the sources are properly credited to the work submitted to them. Even in cases where the legal copyright has expired, of course, the editor must insist that the appropriate credit line is provided to identify the source of material derived from the work of others, since we are also dealing not only with the issue of copyright, of course, but we're trying to guard against plagiarism. Of course, there is the matter of fair use, which means that short quotes from another text generally do not require permission, but a credit line would still be necessary. Simple statements of fact, of course, for example, the dates of historical events or the listing of places that are already in the public domain, do not have to be referenced. Editors are frequently called upon, nonetheless, to determine when and where a credit line is needed and how it should be applied. So this is one of the functions that an editor has, which is designed to help the author in ensuring that all of the requisite permissions and credits are in place. Now, I want to turn now to editors and the rules governing copyright just briefly. One question editors must be aware of is when and where do copyright rules apply? And of course, as you heard from our first presenter, Dr. Sonia, I've forgotten your full name, I apologize. As we heard from Sonia, that copyright varies according to jurisdiction. In the United States, it's essentially 95 years after your death. In Jamaica, it's broadly similar. In Barbados, currently it's 50 years after the death of the author, although I gather they're going to change that shortly to 75 years. But the jurisdiction varies. The rules vary by jurisdiction. So you have to be aware of that, especially because if you are going to publish outside of your home territory, which we of course hope to do, it's important to ensure that you have the rights to publish globally in multiple languages, in multiple editions, and so on. Now, the issue of digitization and copyright is an increasingly important one, and something that we are grappling with at the Museum Journal at the moment, because we are planning to put the journal online for the first time since it was founded back in 1933. So this is a big new shift for us, but it's a recognition of the environment in which we now operate. Now, with the release of books and journals, articles, and so on in digitized format, of course, the issue of copyright becomes much more complicated. As part of the planned shift at the museum, we are in the process now of rewriting the author's agreement to incorporate the digitization process. Now, one issue, of course, with written works that are published in digital formats is that they are more difficult to control. This has resulted in the widespread use of paywalls by publishers. But paywalls are a double-edged sword. On the one hand, of course, they ensure that the author's rights are protected and they get some revenue for their work. On the other hand, it makes knowledge, new knowledge, accessible only to those who can pay for it. Now, this is why libraries, and I wanted to make this point particularly this evening, this is why libraries are so important. You need libraries to provide that access to people who could not otherwise afford access. But unfortunately, even our own library, the UWI library system, is struggling now to pay for the access to all of the material that we would like to have for our faculty and our students. And that's a big issue. It's going to be a bigger issue as we go forward.
Thank you so much, Prof.
I want to end up, yes, I'm going on, I know. History lecturer mode, what can I tell you? Anyway, I want to finish with a brief discussion about editors in the role of generative artificial intelligence, because that was touched on earlier. It's significant, of course, we're celebrating World Book and Copyright Day in the shadow of a boom in generative artificial intelligence. Now, with the massive spread of search engines in the 21st century, plus generative AI added into that now, there's an explosion of information that is available at our fingertips, which you can get in digested form in seconds. In many ways, generative AI is seeking to cut out the role of the human editor altogether in the collection and dissemination of research. But GAI is certainly, again, a double-edged sword. It's certainly much quicker than using a manual process to select and edit material. But unfortunately, simple pre-digested answers to complicated questions without nuance or room for doubt can be misleading and are often utterly wrong. And in fact, AI experts call this tendency on the part of AI platforms hallucination, meaning that they make up answers when they don't know the answer or they actually lie. You wouldn't think that technology could do that, but that's what happens. AI platforms lie or make stuff up. And most alarmingly, AI responses default to racist or misogynist views of the world, partly because the cultural biases are embedded in the material that they absorb en masse. a major issue with the use of generative AI that's not fully understood is the issue of copyright. And Ms. Hines-Lafond spoke about that. I don't want to go into all of that detail, but let me just say that what it means is that when AI produces a document, it is using content from others. How do you identify that material and how do you credit for it? AI does not credit authors. It takes their material and uses it without their permission. That's standard. The other issue is that generative AI has no interest in crediting authors, so it doesn't tell you where the material is coming from. So, to conclude, and I can see the doc is getting more and more anxious. To conclude, the approach of an editor of a book or a journal is qualitatively different in all kinds of ways to that of generative AI. The editor's role is not to synthesize, homogenize, or simplify the work of the contributors, as AI does, rendering individual contributors virtually indistinguishable or anonymous. The editor's role is to encourage the creativity and insights of their contributors and to showcase their individual, unique contributions to knowledge. So, although, of course, editors may set some rules, they may set themes, whatever, to the journal or the book that they are editing, their role is to present the work of others in a consistent format which highlights the unique contributions that they are making to knowledge. So I hope that as we move into this new age of generative AI, that we don't lose sight of the role of the creator of the work, the unique role of the creative writer and so on, but also that we do not lose the human touch of the editor, because without that, we get to a homogenized mishmash, which is actually detracting from rather than adding to the sum of human knowledge. So thank you, Chair. I appreciate your indulgence.
Thank you for the comprehensive talk, Emeritus Prof. Cobley. You have been able to enlighten us on how to use third-party materials while conducting research. But probably my question will be, when we get to the question and answer section, that how then does fair use or fair dealings deals with the issue of use of third-party materials? By acknowledging it and using it for research, do you still need to seek due permission from the owner of the materials you intend to use? Probably when we get to the question and answer section, you will be able to enlighten us on that. But I'm sure the audience now know that you need to seek permission before you use any materials for your research, which is the responsibility of author as well as the publisher. Thank you very much, Professor Emeritus Cobley. I'll invite the third panelist, Mr. Bruce Lochner, to give us a 10-minute talk on navigating data rights, perspective of journal editor, research and publication manager. Please help us work within the time limit. Thank you. You have the floor, Mr. Bruce.
I was struggling to unmute and I've managed to unmute. I'll try to keep within the time limit. I noticed you didn't say what the time limit was.
10 minutes, please.
10 minutes. Okay, I'm looking very carefully at that. Let me just say from the outset that obviously I'm not a lawyer. I'm basically a statistician. That's what this word biometrician means. I'm now a journal editor, and I have been involved in that sort of thing for quite a long time, even when I was still a statistician. My notes are perhaps a little bit rough because I was hoping to prepare the notes today, being a good last-minute person. But we had a meeting at Tropical Agriculture to deal with the problem we have, and the problem we have is that we're getting something like 10 to 20 papers per week, and it's becoming very difficult for us to process them. So we had a meeting about that today, and I think that it's worth bringing that to the fore to show that this Caribbean journal is very, very popular in third world countries. or in tropical third world countries. Now, I've been asked to talk about navigating data rights. I hope you're seeing me, because I'm not seeing I'm seeing myself at the top left, but
We're
presumably
seeing
you're
you.
hearing me. Well, you're hearing me. Okay, whether you're
Yes,
seeing,
both
maybe I look
seeing
so
and
bad.
hearing.
Maybe
We're,
I look so bad that you've cut me off. That's all
we're
right, as long
seeing,
as you
we're
can hear me.
seeing you very well.
Okay. All right. Basically, navigating data rights. Well, the main story is that data is not copyright. Data is facts. And facts cannot be copyrighted. And I hope that, maybe there'll be some lawyers who argue about that. But let's put it like this. Let's talk about the Tropical Agriculture Journal. Every article, well, not every article, but most articles in the journal will present some weather information. This was the weather when we were doing this research. That is obviously facts and cannot be copyrighted. If you measure something, that is still facts. If you measure the height of a crop, it's regarded as facts. If you actually go out and interview people and survey them, what do you think about this? What do you think about the we'll get away from agriculture. What do you think about the President Trump? What do you think about the Prime Minister? The answer is coming from people. It's facts. It's not something which can be you can copyright. However, if in some way it's creative, or arranged or structured, maybe you can copyright it, but I don't want to. We don't really deal with that sort of thing in academic publications. Having said that, some years ago, well, not that many years ago now, 4 or 5 years ago, somebody sent me from another journal, a peer-reviewed thing about using Twitter to somebody managed to survey the whole of Twitter and find out what the food preferences were in different countries. And basically, this was a new method of analysis, which maybe could have been copyrighted. But the thing is that when academics think of a way to analyze things, new ways, they don't want to copyright it. They want other people to do it. And again, when things are analyzed in a certain way in tropical agriculture, some authors say this is based on some work which was done in 1950 or something. Sometimes they don't, because it's well known. And we don't insist upon, we know that, unless it's relatively new and unknown, then we need a reference. So basically, academics are not looking to, if they find a new way of using data, they're not looking to copyright it, because they want other people to do it. All right. So I've said now that, a lot of weather data and things are facts and cannot be copyrighted. I can give an example. In Trinidad and Tobago, I don't know whether it's a situation now, but when I was working, not as an editor of a journal, but when I was working in agriculture research, the agencies who were collecting weather data, the Meteorological Office and the various others, were charging for information. If you ask them, can you give me the weather data back to 1950? They'd say, yes, but you have to pay for it. Now, the way around that was always that this is for academic purposes, and they said, oh, okay, you can have it. There was also the way around it, oh, I know somebody there and he can give you the data. But having got that, it's not copyrighted. I could, if I ask and get it for academic reasons, they can't stop me giving it to you, because it's facts. What went on has gone on from 1950 to today. If you want all the maximum temperature for every day from 1950 to now, that is facts, and it cannot be in any way copyrighted. So even if it's sold to somebody, I suppose it's a similar thing. If you sell a book to somebody, it doesn't stop me somebody else reading it. I see the lawyers thinking hard about that, but let's not. The other thing which I want to mention here is obviously data these days means much more than it did years ago, when it meant just numbers. Data is, any information is often regarded as data. And somebody wrote a book some years ago about hiking routes again in Trinidad and Tobago. It wasn't a terribly good book, but it was a book. Somebody else about 10 years later said, oh, I can write another book, a better book than this. And they were threatened with copyright. No, these are our routes. These routes are ours. In fact, what happened, because they didn't really want to quarrel, is the second book was gave on different hiking routes. But I don't think you can sort of copyright that sort of information. Somebody can. I'm not talking about plagiarism. You don't have to copy. You can go back on the same route and write your own description of the route. You don't have to copy the other person. And I think if you go elsewhere to many other countries, you can, if you're interested in hiking in the mountains or something, you can buy more than one book telling you how to hike through these mountains. I'm watching the time very carefully, Chair. Of course, we know that trade secrets can be copyrighted, whether trade secrets are presumably data. That is a little bit different from the academic world. When the academic world, we want people to know our information. If we are producing Angostura bitters or Guinness or something, we don't want anybody to know information because we don't want other people to do it. The tropical agriculture, going back to the Tropical Agriculture Journal now, we do have a very active editorial process. It takes a long time to look at every paper, and we do edit it. We make changes, and we go back to the author and say, these are the changes we make, or we make them make the changes. We don't like it the way you've written it, write it this way. I sometimes wonder is how on earth this was done before the information age, because I mentioned there was a long list of countries where we get papers from. Let's say I got one from China today. If now I can email somebody in China and say, I don't like this or change this, and they return. How on earth was this was done 30, 40 years ago? I don't know. So perhaps somebody can tell me. And the other point about rights of royalty rights, we're in fact the other way around. The authors have to pay to get their papers published, and that is the standard in academic world now. It used to be that we sold the libraries bought copies at a very high rate. Something like Tropical Agriculture if you want to buy an individual copy, you might have had to pay 30, 40 US, I don't know, but a library has to pay 10 times that. Now we don't publish any paper copy. It's all electronic, and it's free to air, and the author has to pay. Our fee at the moment is 200 US, which many journals charge far more than that. We know that most researchers in tropical countries cannot afford those high rates. Even 200 US, as somebody from Mozambique was pleading with me, that's an enormous sum of money, Can you let us do it for free? When in fact, what we came to do, we came to an arrangement. If you do some peer reviewing, we'll allow you to send us some papers which we'll consider. And I'm watching this time, and it's nearly 10 minutes already. Is there anything else I want? There's a few things. Yes, about copyright. What we have is, like most journals, yes, like most journals, we have a little bit about, a little copyright blurb, which used to be, when you bought a journal, you'd see it at the front of the journal, what the copyright rules are, no part maybe without permission, etc., etc., etc. Nowadays, now everything is online. People just look at the article and probably, although the copyright is there, they probably don't see it. It is, again, we don't want plagiarism. We look every paper carefully. We reject some papers because it looks like plagiarism. They always quarrel with us. It's not. We don't know. We say, well, this is very similar to something which has been done before. But on the whole, our authors want their work to go out there, and so they don't want any restrictions on it being known or used by other people. I'm getting a little bit short of time. I can give an example where not us, another, not a journal, but an international institution who are producing journals wanted you actually to sign off the copyright to them if anything they published. And I know there was a Trinidad author who refused to do that and decided to publish it himself. Well, he published it himself, but he didn't have that international audience. So that's just just a little thing here. In the world of academic publications, we don't have copyright clashes. Let's hope it remains so. I wouldn't like to get into the stage where we do begin to the whole world is becoming much more legally legally worried. Well, you know what I'm trying to say. I hope that we remain fairly free in allowing academic work to be relatively free of copyright worries. Now, I'm not talking here about intellectual property. If somebody produces a new variety of tomato or a new type of hot pepper, that is intellectual property. You can still write an article on it, but actually it's the actual product is intellectual property. But when you're writing about it, that is not a copyright issue, I hope. Okay, somebody might say, what about data protection? Data protection rights are something completely different. It's if when I go to the US or anywhere like that, they make me fill out, or not the US actually, they don't make you fill out a form anymore. Trinidad makes you fill out a form which has got even more horrible now it's gone electronic. I have to put out so many things, but there is intellectual property there. They cannot, the Trinidad immigration officer cannot take my information and give it anywhere, because there is some intellectual I hope there's some intellectual rights there. So Chair, that's a bit of a rush, but I know that you wanted me to finish in 10 minutes, and I know there's 2 more speakers who I want to listen to. So apologies for the bit of a rush, but I hope that I got a few messages across, and I hope I didn't annoy the lawyers too much.
Thank you so much for the presentation. It was a thought-provoking talk, Mr. Lochner. And I've been able to learn that payment for publication does not mean that what you intend to publish is you are publishing with a pediatric journal. Doesn't really mean that. Because the mindset they created for us is when you pay for publication, it is deemed that you are paying for a pediatric journal. But there are some standard journal that demands payment. And that also gives you the right over your work because it's an open access. So I could draw that from your presentation. Thank you so much. I'll welcome the next speaker. That's our panelist, the person of Dr. Alima Dikshang. Please, I will advise or encourage that you help us stick to 10 minutes. So you should be talking to us about navigating authors' rights and retained rights from the academic perspective. You have the floor, though.
Thank you, and I'll do my best to stick to the 10 minutes. I'll just first start by thanking Rich and the Libraries Cave Hill for the invitation, and to stand on the great knowledge presented by persons before. There's a lot of overlap, so thank you all for covering important ground. And so I'll go straight into it. I sort of want to start by just setting a foundational idea, which I think was raised by Fiona earlier in her presentation, that as a starting point, as academics, community of researchers, creatives, we in fact are the original owners of the output produced, whether these outputs are in the forms of manuscripts for journal, literary, visual, or performing arts. But I do think it's worth thinking about the ethics of ownership and the negotiation that is required oftentimes when we do work with communities, and the extent to which these communities then end up having access to that work. And I think, we think about our academic communities, our creative communities, but also the persons with whom we work to produce this research. In the social sciences, these persons might be referred to as communities of research or research participants. But there is that idea of ownership that we navigate even before we get to publishers and working as authors with publishers. And then, of course, I'm not going to cover the important ground covered by Prof. Cobley around the complications arise with the greater use of AI in publishing, and I'm sure some of that will come up in our discussion towards the end. But I do want to issue a few caveats. I come to this work as a Caribbean feminist sociologist, and I've served on I continue to serve on two editorial boards of journal Feminist Africa and Journal of Eastern Caribbean Studies, and these journals come from my two most favorite regions in the world, the Caribbean and Africa. And I also am not going to engage the conversation around predatory publications. Professor Landis gave a really great presentation a few weeks ago, and I'm sure that is archived around the politics of predatory or deceptive or exploitative publication. And so that is kind of letting you know what I will not touch. But what I do want to think about are some issues related to retention by authors of their publications' rights. And I think in many ways we were mentored into the academy and encouraged to relinquish author rights to publishers that end up in many times. And I'm going to focus a lot on the journal because I know Christine focused quite a bit on publishers of books and so on. But a lot of these journals end up behind paywalls, and we were told that it is a necessary evil in order for us to appear in refereed outlets. And then for a very long time, the idea of open access was very much so what we would consider murky waters. But prior to the I would say 2000s, the global political economy of peer review was not so intensely contested to the point where now we are having real conversation, like you mentioned, Bruce, about access and opening access so that a wider cross-section of people could reach our work. And then, of course, a number of challenges are posed. So the cost of publications, notwithstanding questions around the ethics of paywall, mention was made of economic disparities among global universities. For example, to be able to afford, we know our library at the University of the West Indies, our libraries are grappling with high subscription costs. The labor of peer review is virtually unpaid and provided by faculty from the very universities that may or may not be able to afford this subscription. And then, of course, there's the intellectual labor required to produce these works by our creatives, by our authors, and they're hired by the universities that sometimes can't access their works. And then, of course, there are the inequalities of access. If we want students to be able to engage our work, the communities, our colleagues, we have to think about ways in which we democratize the publishing space. And I was really pleased to hear mentioned by Christine about how the role of the University of the West Indies Press, and I would add Ian Randall, publishers, in ensuring that Caribbean works are featured in high quality peer-reviewed outlets. And so when we think about author retention, we are really talking, as Fiona was mentioning earlier, is the extent to which we have control over the intellectual property that we create, right? And retaining those rights has a bit to do with the extent to which researchers are able to make accessible or make decisions around how their work is shared, how they can access, how they may be used, how they may be built upon, and so on. And so in the literature, you will see access to these different categorizations that tell us about the extent to which authors can withhold their rights. And so what is often regarded as the diamond category in open access is when there are no fees attached, what Bruce mentioned earlier. So I think about our journal, the Caribbean Review of Gender Studies, that is peer-reviewed open access, published from the Institute for Gender and Development Studies, St. Augustine unit. And I also think about the Journal of Eastern Caribbean Studies that didn't start open access, but more recently is now making its work available open access. And then of course there's Feminist Africa, published from the University of Ghana, that is also open access. And so it's really important for us to preserve these spaces of high quality published output by our universities in the majority world, where our scholars from all over the world, including in both the Africa diaspora and the Caribbean diaspora, see as important, and those of us who live here geographically, important outlets for us to put our work. And several of these are open access. And then of course, we talked about those article processing fees, which oftentimes, again, we are not always able to afford. And so there's a movement to try to remove these fees and make more accessible the works of persons who are actually publishing in these journals. And I'll share I'm not going to go through all the categories because I want to get to some other areas within this 10 minutes. And so when we think about this, I also want us to probably think about how these author accepted manuscript permissions as another way in which researchers are also navigating making their works open access when their work end up in journals with the paywall, where you have to pay for subscription. I'm not necessarily thinking here paying for publishing in peer reviewed, but paying for subscription. So sometimes there are arrangements that allow us to deposit an AAM version into our institutional repositories upon publication, and several universities have such institutional repositories. Sometimes if you do a Google search for an article, you notice you may be able to find a version of the article that is just before publication. And there's several repositories that are available that where you can see these open access pre-print versions of works appear. And then of course, when we think about rights of retention, what we are thinking about, like I said before, those early strategies tended to focus on how do we get authors to retain their rights in a context where there is this paywall. And I see you coming in fast, Dr. Palema. I'm going to wrap up really soon. And so I want to give two quick examples of how this works. One, how in a number of American institutions they've thought about retention of rights through actually paying for these, but also, for example, the emergence of the European Commission's through the European Research Council, the Plan S. Right. And this allows for, where there is funded research, there is a requirement for the publication to be open access, because this research has already been funded and paid for. And so some of the things we want to think about when we think about author retention is the aiming to influence this tendency to want to influence market outcomes, but not necessarily say that. So if you go to like Elsevia's page, you will see two options: the pay to publish, and under the pay to publish, you have this whole idea of how you might retain your authorship rights through Creative Commons attribution, or pay to read, where the onus is on the person who wants to be able to access this journal behind a paywall, whether it's an institution or individual, to pay. And you could, I have the links there that I can share with you. And then of course, when we think about publications of book, who retains the copyright? And it takes us back to the earlier discussion. When the editor in the contract, and I actually excerpt this from a contract with a publisher we've worked with, the idea that the editor has asserted the right to be identified as originator, whereas the publisher asserts the right of copyright, even though within the contract it talks about both the editor and the publisher, and it almost gives you the impression that it communicates joint copyright, but it doesn't quite do that. And the last thing I would mention here is the experience of working with Christine when she was at with Ian Randall and with Christine more directly, to publish methodologies in Caribbean research on gender and sexuality, which was a hybrid publication that required permissions for 19 previously published work and of course the 10 new works, we didn't require permission except from the authors. And the fact that we had so many diverse experience of having to pay some publishers to republish, the authors giving us permission, but still needing to go through the publishers. So we wrote both authors and publishers. And that experience sort of opened up the idea of ownership and what it really entails to publish such a collection that requires 2 and sometimes 3 levels of permission. And I close by saying thank you, a huge thank you to publishers like UWI Press and Ian Randall that continue to provide the Caribbean, show the depth of the Caribbean's intellectual rigor through a range of journals and books published by UWI Press and a range of books across a variety of fields, disciplinary, multidisciplinary, and interdisciplinary by both Ian Randall and UWI Press. And I'll stop there. Thanks.
Thank you so much, Dr. Deshan, for that excellent presentation. You have provided us with very practical insight in navigating authors' rights, specifically as it applies to you paying for subscription or paying for publication, and making us understand that there's no crime in paying if they have the standard and they don't fall within the categories of predatory journals. So I would like to welcome the last but not the least panelist on this discussion, Ms. Mayna Douglas, to give 10 minutes talk on publishers' agreements and the impact on implication for libraries from law librarian perspective. Ms. Douglas, you have the floor, please.
Thank you so very much. I was speaking without my mic. Thank you so very much for this opportunity to speak this afternoon. And like Dr. Deshan, as well as Mr. Bruce Lochner, you have said it all, and I don't have much work to do. Dr. Hines Lafond, Casey, when you spoke about copyright, ownership of copyright, I felt so comforted, but I just want to tell you that as the conversation continued, I realized that our fear as librarians about this issue of copyright is justified because you made it simple, but it's justified. It's not as simple as we think. It is extremely complex. And I just want to tell you about a situation that I had with a PhD student who really needed a piece of a book that was published in Jamaica before Jamaican independence, but it was published by a British publisher, and it found its way to Netherlands, and there were no other copies anywhere in the world. And so when we tried to get access to that in order for the student to exercise her fair use, it was a whole lot of complication. The person had died at a certain time, and the 50 years, our update of the legislation had already passed, retroactive only to 2012. And so all these kinds of publication rights and publication permissions came into play. Eventually, I was able to get a limited access link to a digitized copy of the book after careful negotiation of including and pressuring the Netherlands University librarians to say, listen, we have Life Plus 95, but you have, I think it's Life Plus 70. And the book was published in Jamaica by a British author, and so on and so forth. And then they softened up and gave us access for a limited time via a link. So digitization is one of those things. What we're seeing is a situation where academic publishing is undergoing major changes, and Dr. Desang has spoken about that. Mr. Buckner has also spoken about that. So there is a shift in the subscription models and to hybrid agreements, which is one of the things that librarians are grappling with. The rise of transformative agreements is very complicated for us, and we are having that challenge. So our push is really for open access to research output. But we did hear our colleagues talk about this whole open access movement and how it is not just fully open. It is a hybrid kind of open access where you also have to pay to publish in open access. And so there is all these hidden costs and all these little costs in the publisher's agreement for us to be able to access the open access nonetheless. And it is twofold. So it's like a double payment for the author as well as for libraries to pay for these. So these are hidden things that have implication on us that we have to notice and take note of. Libraries and librarians endgame is really service position. So like Mr. Lochner, sorry, we really don't want to care too much about copyright, but we have to, because we're under that kind of restriction. In the Caribbean or the University of West Indies, we have agreements with Jam Copy, for example, and so we have to pay in order to ensure that we can apply fair use to gain access and to copy published works. And therefore, no matter how much we push and no matter how much our service provision would just want to be fair use and full access to the resources, we still have to maintain our vigilance as it relates to these authors' agreements. So the question is, are these publishers' agreements truly beneficial to libraries? And the truth is that I would want to say, Ms. Randall, you're here, but I would want to say that in our desire to give free access to our resources, I would say no. But in our desire to also publish as librarians, I would say yes. So we're in two minds here, and we have to navigate all of that complication. Ownership, from ownership to licensing. Libraries are no longer own digital content. So libraries would have print in the past, but now in our publishers' agreement, the agreement that we have with publishers to display the digital content of what we used to own in print, we don't own it anymore. We used to own the print and we could just go to the shelf, pick our books off, and we could make as many copies of an article and supply it to another library, to a user, and so on and so forth. But guess what? Now that we are being pushed by agreement to digital content, we no longer own it in that way. And so there are a number of restrictions. And so I am like Mr. Lochner, where sometimes this whole thing of copyright irritates me, but we have to abide by it. So this access of controlled licensing, access is controlled through these licensing agreement, and we have to abide by it. So for example, I just yesterday, I had a student got in touch with me and saying, I think it was Tuesday, and said to me, oh, Miss Douglas, you know, I need to read so many chapters. It was like page 1 to 65 of a book, the lecturer's book. And the lecturer is the author of that book. And we had no more copies in the library. We just had like 3. One of them was out on 3-hour loan. And I said to the student, you know what? You need to go to the electronic version on UWeLink. And when she went there, she was able to download 1 chapter. And then after that, she attempted to download another chapter, no access. So I went and looked to see why she was having that problem, not having access. It's giving her some message. Then I realized that myself having downloaded a chapter in recent times, it gave me a message that I can no longer download anything. And so I fiddled around with it a little bit, and I realized that I could only read on screen. So these are some of the challenges that librarians are facing, because students don't necessarily want to do screen time. You can't print it, you can't download it and save it on your device, but you can read it on screen. And so there is also that challenge of screen time. So when we're entering into agreement with publishers, we have to know what restrictions are being imposed. And these include Mr. Lochner, who talked about data set. Was it someone's talked about data set? Yes, it's Mr. Lochner who talked about data sets, and that they are free and that they are not copyrighted and so on and so forth. But one of the things we have noticed as librarians about publishers' agreements is that they impose restrictions on no text and no data mining. And these are challenges that we face that we would really want to have our clientele in the library to have access to data mining. In fact, librarians are now moving into a new territory and having this kind of fancy endeavor or thrust about research data management and want to set up research data management databases and so on and so forth. And so we are wanting in our publishers agreement to have access to these no text data mining facilities. It's important for us. And so there's another thing related to AI-based research. Now, we're finding that even though we are signing these licensing agreements, we are being restricted in terms of AI. Very few publishers want us to use an AI which is not owned by the publisher, to apply that AI to their database. And this is one of the restrictions that we are finding in our publishers' agreement with libraries.
Thank you, Ms.
They
Douglas.
want
Can
to
you wrap
sell
up,
us.
please?
Pardon me? Wrap up.
Can you wrap up, please? Yes.
Yes,
Thank
sure.
you.
They want to sell us the AI within the database itself. And so our rights are being reduced by these publishers' agreements. So I'm going to wrap up very quickly. So there are all these big deal problems that we face as a library. Single titles that we are used to in print are now transformed to marrying two titles together, or marrying a book with a title. And so if we have to buy the book or buy one journal, we have to buy another one. And now we have moved to things like bundles, journal bundles, and they're overlapping, and that is in our agreement. So different databases have different content, but a good portion of those content are overlapping. Evaluation. So, and also it pressures librarians to do the evaluation of all these data bundle packages. And so we have to be vigilant. The modern contracts they're sending are quite intimidating. So certainly we need the services of Miss Fiona Hines-Lafont to assist us, and on the other campuses, our legal counsels on the campus, we have to refer these agreements to them because sometimes we feel that we are being cheated out. But stringent budgets we need to, because we are facing stringent budgets as well, we have to peruse these licensing contracts, these agreements carefully to see whether we are shortchanging ourselves. So all these contracts from publishers, I mean, they're not all bad, but these kind of subscription models and transformative contracts, they're increasing our financial strain. And so the question about fairness in terms of the amount of use that you have for these databases, these bundles, it is not fair in terms of the cost per use. So we are hitting back and we are doing things like cancellation. And so when we use the database in a particular way, for example, AI usage on them, we find that we have sudden data loss and sudden access loss and those kinds of things. So let me move a little faster. you know, so we have to look at the pros and cons. How are we doing our transformative contracts? We have to look at the pros and the cons. And also, it's important that we look at the profile of our staff in the library in terms of their capabilities, their competencies, to peruse these agreements and point out what we are, you know, afraid of, what we find unsettling to our legal counsel on the campus, so that we can get a good agreement from our publishers. There is increased workload for us. It brings increased workload, and the complexity of the staff is very overwhelming. But the truth about it is that it's a lot of things that we have to contend with in terms of how these contracts and these agreements are presented to us, and how we have to fight to understand them and to figure out what is it we are going to do, whether we are going to sign or not to sign. Let me just move on more to the end. So I just want to conclude by saying that Transformative publishes an agreement aimed for open access, but we are not necessarily getting our best shot from the open access publications, or it is not comprehensive enough, and therefore we still have to engage in these transformative contracts and agreements with publishers, which impose high cost on us. The publishers are controlling our access. We have limited user rights, and so on and so forth. So my final thought is that with publishers' agreement, libraries face a critical balancing act of affordability and independence, and also our ability to serve our students. And therefore, I, like Dr. Desang, I would want to recommend that as Caribbean librarians, we do what we do to drive our independence. We have to engage in creativity and value added, innovation, and commercialization of our own works. Those whole slew of publications that we are putting out, our books, our journals, and we can dig up all these old journals, digitize them, sell them off. UWI Press can play a role in that. And we can sell them off to big publishers on the licensing agreement, so that we can earn something from our intellectual property. It is important. Our institutional repositories, same thing. So we have to engage in creativity, added-value, innovation, and commercialization, because the truth is that while we are engaging in these transformative publishers' agreements that are so complicated and so anti-library services, we can also benefit from the best practices that are within our own creation, in our own books, in our own journals, and we can get monetization from it to pay our bills. Thank you so very much.
Thank you very much, Ms. Douglas, for those important insights on the publication agreements and implication for libraries. Open access demand payment for authors, right? But as it is, we know that libraries face a lot of challenges to get us to be informed, or to make those information we need to help our research available for us. But those information are still there. We need to access them. As much as there's difficulties in or challenges in managing those information, they make it available for us. So it is our duties as authors to visit the library to access those information. Thank you very much once again. And I want to appreciate all panelists that have spoken so far for those insightful and thought-provoking presentations. So while I will expect our audience to pose their questions to the chat box, we will proceed immediately to, before we move straight to our question and answer section or discussions, I want the audience to be attentive to realize that we have heard important perspective on publication rights, on the structure, implication, publication agreements, and the authorship right as well. And then there is a need for researchers to be more informed, strategic in protecting their copyright works. So we proceed straight to question and answer section. I would like to take some few questions from the chat box. The first question is to Ms. Randall. Yes. How is the 90% net minus owner royalty, to say of 10% of net revenue, generally splitted? Which whom and for whom and for what? I think the person wants to know more about the distribution of royalty in your published work.
So thank you for that. Royalty rates differ, and essentially what will happen is, as I've explained, whatever the publisher receives in their hand, the author receives a percentage of that based on what you negotiated. And the percentages can differ based on whether it's sales of the printed book, sales of the audiobook, or sales of the ebook. So if I get $10 and your royalty rate is 6%, you're getting 60 cents? 6% of $10 that is what you are getting. So that is how it is split. And essentially what you have to remember, is that the publisher is the one making all of the financial investment. And so what you are paid it's not akin to a commission. It is really a royalty, an earning on your work. And it is important for you to look at and negotiate those percentage rates.
Also, the percentage are negotiable.
Absolutely. Everything in a contract is negotiable. Absolutely everything.
The one saying that is they make most authors to realize that you are the mercy of the publisher. So whatever is presented to you, they expect you to just accept. We have helped you to build expertise in your publication, so you should be expected to accept whatever offer we are giving you to make your work to be seen.
It depends on which publisher you're working with, but yes, essentially the publisher is the one who holds the handle, because we are making you an offer of what we are prepared to do to cover our investment. But that does not mean you necessarily just accept everything. And as I said, I've seen in the past where people don't even read their contracts. I've had authors who 10 years after publication are asking me for a copy of their contract. So, that is important, that authors really take charge of the ownership of their work. Yes, it might be that the negotiation amounts to no change in the contract, but you have the right to negotiate.
Thank you very much. I hope you have answered the question. The person that posted the question. Yes,
Dr.
please.
Palemo, sorry, Chair. Ms. Hines, Fiona Hines, has 2 points she wants to make. Thank you.
Thank you.
Thank you. Sorry to disturb. So I just wanted to make some points regarding what has arisen in everyone's speeches, not in any particular order, save and except to the last point. Contract is king when it comes to copyright on the whole, all IPRs, and of course, publication agreements. And negotiation and contract is queen to the king of the contract, okay? Having said that, easy language. Contracts need to be reduced to easy language. So I think for the publishers in the room, not everybody speaks complex legal language. And I'll get back to that because that came across. So we need to reduce it perhaps to make it simple so that they can understand. That's point one. Point two, to the owners in the room, if you are creating a work and you're a part of UE staff, UE has an IP policy. So just remember that 5% that Ms. Randall referred to might be 2.5%, because the university will own, according to the IP policy, a percentage of the work if it's created in the course of the UE's intellectual property policy. I think that listening today, I've recognized that some of you are thinking that whole 5% might be yours. It may not be if the work is created in the course of your employment contract. Number three, data. I know I said two. Data is absolutely not protected to that point. Mr. Lochner, you're 100% correct. However, compilation. So what can be protected though is how the data is compiled. Okay, so data compilations are 100% protected in copyright, provided they have the necessary creativity. So it's one thing to take the data; it's another thing to photocopy the data. Because when you photocopy the data, you're photocopying the compilation, which is going to be a big no-no. If the data goes beyond simple ideas or facts, however, because that's possible, data is not limited, it's just a word. If the data goes outside of ideas and facts, you're going to have a problem because you might then run into somebody else's copyright. So really you have to look and say, what is this data? What comprises the data? And also to remember that compilations can be protected. Lastly, the reprographic arrangement exists not just in Jamaica for Jam Copy, actually not just Barbados Beat Copy. So all of the campuses comply with the reprographic rights. And however, that does not eclipse the digital rights for those contracts that are now coming for the digital copying, the digital production, the digital access of books that the university libraries are using. And lastly, just as a point, we don't use the term fair use in the Caribbean. We use the term fair dealing. Fair use is a North American term, but for us, just going forward, we're going to happily say it's fair dealing because that is, it's whether the dealing is fair. It's very similar, but it's a term of art coming out of statute. Dr. Cook, I thank you so much for allowing me to intervene, and I turn you back over to your meeting.
Thank you for the enlightenment, Ms. Fiona. So I'll take you up from there. We have the next question, which will be posted to Professor Emeritus Cobley. This person said he resides in the US, although a Caribbean, and writes mainly on Caribbean experiences, but he would like to, if he wants to publish with UWI Press, where will his book be distributed? Is it in the Caribbean or in the US or in the UK or global world? Will it be available on other research platforms like Amazon, international retailers? That's the first question.
I'm sure that
The
question is for
professor,
Christine,
yes.
not for me.
Yeah, I think that's a question for me. And I mean, anybody who is familiar with UWI Press would know that we publish regionally, but we distribute globally through every platform, every avenue. We are on the Amazon, we are on the EBSCO, the JSTOR, the Project Muse. We operate at a global level. And so our part of our mandate is to ensure that our Caribbean voice has a global audience. So our reach is definitely global.
Thank you so much for the response. In that same question, the person wants to know whether you can just put him through the process of, so can you walk me through how UWI Press distributes and market title to Caribbean diaspora or audience in the US?
I don't think this is the forum for that. It would take too long.
So obviously the person needs to contact you via email.
Or visit the UWI Press website. There's a font of information there on all of that.
So for the audience who wants to know more about UWI Press, please visit the website. You get the comprehensive information on that. Thank you so much. Our next question is, can the panel comment? Okay, this is for Dr. Deschamps. He said, can you comment on predatory publishing and the status of such publication for academic advancement?
Thanks. I actually saw it, and hence why I raised my hand. There was a really great session, and I'm sure it's recorded a few weeks ago, that sets out very clearly and clinically UWI's policy on predatory publishing, which is that you cannot include predatory publishing under peer-reviewed publications. I think most recently, and persons are strongly encouraged to do their checks. I think we have enough information these days to know how to avoid these publishers. If a publisher is hunting you down to send your paper that they know nothing about the contents, and you're getting these random emails, and you're getting from editorial boards that once you do your investigation, they're made up, and they're definitely telling you they will pay, they will accept it in no time. Those are the journals to avoid. But also how they're treated too if you're preparing your CV, for example, for a job or for promotion or for review, you cannot include them as peer review. You actually have to include them under a category called non-peer reviewed. And you will just be encouraged to totally avoid that. And I would say mentoring in this regard is really important. Do your own investigation. You're your best advocate, and but also talk to colleagues with more experience in publishing, so that you don't end up in those situations. And there are a lot of sort of gray areas around predatory, exploitative publishing. It is not that, yes, there is a clear pay for publication model, but your work is certainly not peer reviewed. And that is the key distinction. Paying for publications has to do with, publication fees and so on, and the jury is out on that. But if you're paying and you're told within a couple days turnaround that they're going to publish your article, it's probably a predatory publisher, and absolutely avoid it, because you're not going to, some people have gotten in the position where they've ended up putting their really good sound research in these predatory outlets, and then they can't get the requisite credit for it. So avoid it at all costs.
Thank you so much for the explicit response to that question. I would like to ask the Professor Emeritus Cobley a question, because that's the last question in the chat box. I'll be asking, if you use third-party materials that are in public domain, and you acknowledge the author, will it amount to fair use? Or you still need a due permission before you can use it?
Well, Fiona, who I called Sonia, I apologize earlier on, was just saying that we don't, in the Caribbean, they don't talk about fair use. That's a US thing, but I did use fair use.
Yeah,
but essentially, what essentially we're talking about there is material that is in the public domain, is accessible, therefore, to everybody. And so it's not a question that by using that material, you're infringing anybody's copyright. Now, stuff that's in the public domain, it may be because the copyright has expired, because the time since the author died or whatever has expired, and we talked about the various jurisdictions and the rules there. Or it may be that it's material that is commonly shared, as Bruce was talking about, particular kinds of data and so forth, which are generally acknowledged and accepted. So I think one of the issues often is for authors, particularly authors who are new to the process, is to determine what needs to be credited and when and where and how to be credited. And as part of the job of the editor and also the publisher to make sure that the author has good information. And if there is any kind of doubt, it is a good idea, as Halima was saying there, to ask somebody who has experience in the field to advise you. It's not a good idea to make decisions about these things and to go ahead and put stuff in your article or in your book and so on without determining definitively who owns it. And so that is incumbent on the author in the first place to do, but it's also the responsibility of the editor to check, and the publisher can run into legal jeopardy and financial problems if you don't do your job as an author and editor in that regard.
Thank you so much, Prof. So, and this marks the end of the panelist discussion. I say thank you once again to all the panelists for their valuable insight and contribution to this discussion. To the audience, thank you for your engagement and thoughtful questions. And then this brings us to the end of these panelist sections on understanding publication rights and publication agreements. So it's my pleasure to now hand over to Ms. Natalie Banista, who will deliver the vote of thanks.
Hi, good night. Good night, everyone.
Awesome. Happy World Day, World Book and Copyright Day
Thank you.
to everyone.
Good night, and thank you for being a part of the panel discussion to celebrate World Book and Copyright Day. A special thanks to Miss Pauline Nicholas, our dedicated campus librarian, for her warm welcoming remarks. I wish to extend heartfelt gratitude to our featured speaker, Mistress Fiona Hines-Lafon, and our panel moderator, Dr. Adututu Aina Peleno. Our sincere appreciation goes to our esteemed panelists, Professor Emeritus Alan Cobley, Dr. Halima Deschamps, Miss Myrna Douglas, Mr. Bruce Lochner, and Miss Christine Randall. Thank you all for a truly insightful and thought-provoking discussion. We are enlightened and inspired by the diverse topics presented here tonight. I would also like to thank the coordinators of this event, Dr. Yolan Cook, representing Rich, and Ms. Beverly Wood, Scholarly Communications Librarian at the Sidney Martin Library. Our gratitude goes to the Campus Marketing Department, Campus IT, especially Sam Eugene, and the teams of all the libraries of the Cave Hill campus. It has been a genuine pleasure having you here this evening. Last and very important are the participants, for staying even though we have gone into overtime, for attending this gathering. Thank you for your interest and the questions and comments you made. We hope you have found this evening's event valuable to your career and life. Thank you so much. Good night.
Thank you so much.
Good night.
Thank you very much, everyone. It has been a real pleasure to have you here. We appreciate that you are a part of our World Book and Copyright Day Forum. We ask that you continue to look out for other presentations, other notices coming from the campus libraries and Rich. As you note, we are very much looking to educate our communities and to enlighten all of us on topics of interest. Best wishes to you, everyone, and have a good night. Enjoy the rest of the World Book and Copyright Day.
Thank you. Good night.
Good evening.
Thank you for
And
coming.
thank you for your
Good night.
indulgence.
Good night, everyone. Good night.
Good night.
It was a wonderful evening.